Hi, good afternoon if you're on the East Coast. Good morning if you are out west or way out in the Pacific. We noticed we had a few folks out in the islands. We are really pleased that you're joining us today. My name is Aaron Lacey, and you're listening to Introduction to Intellectual Property Law. It's part of the Higher Education webinar series offered by Thompson Coburn. We're a law firm based in the middle of the country in St. Louis and have offices around in different places like a lot of big firms do. As we get started here, I'm just going to run through some housekeeping, and then I'll introduce our speakers, and we'll be off to the races. As always, with all the webinars in this series, this webinar is accredited for continuing legal education credit, right? So if you are an attorney and you are listening in, you do have an opportunity to get CLE. We've created some polling questions during the presentation, which really just amount to you having to click and show that you're still here, but please make sure that you do that so that you can get your CLE credit. If you look at the bottom of your screen right now, you'll see that there are a number of what we call widgets. You can use those throughout the presentation. All of them are resizable and movable, so please feel free to do so. We want your desktop space to accommodate you and your needs. You can expand your slide area or maximize it to full screen. If you have questions during the webcast, we would ask that you use the Q&A widget that's down at the bottom and just type in the question. And at the end, we've allotted some time, and we'll try to get through as many of those as we possibly can. Also, I'll note that there's a copy of today's slide deck in the resource list widget. So if you'd like a copy of the slides, you can go there and pull them down. Also, there will be an on-demand version of this webcast. All of our presentations in the webinar series, in fact, are housed right now in our on-demand site, which is on our website and powered through YouTube. And in fact, I'm going to go ahead and advance the slide here and show you, if you look, this is our webinar series schedule for this year, and you'll see that the first several are highlighted. Those are live links, so if you pull up the PDF that's available on the resource list and you want to go back and listen to any of those, you can. And this presentation will be available live, free, on demand on our website, hopefully by tomorrow. And so please feel free if you like to go back and visit it again. Finally, I will note we always ask, if you have a few minutes after the presentation, please fill out the survey. We try to make sure that every webinar we do is better than the one before, and your comments really help us to accomplish that. So I'm the host of the webinar series. My name is Aaron Lacey, but I'm not the speaker today. You're going to hear from two folks who know a lot more about intellectual property than I do. The first is my partner, Steve Ritchey, who, as it says on the screen, advises clients on patent applications, all things patent from soup to nuts, particularly if your invention involves soup and nuts. He provides counsel on licensing, technology transfer, and has worked with lots of different institutions of higher ed on a wide range of technology transfer type issues and getting, I love that line, inventions to market. I wish I did something as interesting as getting inventions to market. It just sounds good. He also, I will say, has the best beard in our law firm. Jennifer Visintine is here as well, and we'll be doing the second half of the presentation and be focusing on trademark and copyright law. We know lots of institutions of higher ed have lots of issues around trademark and copyright in all different sectors, really without regard to what you might do or how you might be organized. She advises clients on trademark selection, registration, enforcement, and works specifically not just with higher ed, but works with higher ed as well on protecting their valuable intellectual property. So, with all of that having been said, I will turn it over to Mr. Ritchey.
Well, thank you, Aaron. And I'll get started. A lot of ground to cover, and definitely look forward to going through what is involved in patents. And so I think we'll be submitting a revised slide deck because I think a couple of the slides are missing. But there are different types of intellectual property that result with technology. So what I'm going to go through is kind of what is a patent, the types of patents and applications, contents that you need in a patent, the typical examination timeline, some best practices, some other things that go with marking inventions with patent numbers, some specific defenses, challenging of patents, and some provisions that are specific to universities as well under the Bayh-Dole Act. So what is a patent? It's a right to exclude others from practicing your invention. It's not a positive right that allows you to practice your invention. So it is a little bit different than the common understanding. The preventing others, you can get an injunction perhaps, but since the Supreme Court's decision in eBay a few years ago, it's more difficult to get an injunction, and usually your remedy for infringement is damages. Patent protection is a country-by-country basis, so you would have to file in individual countries, United States, Canada, China, wherever you like. So you don't get a worldwide type of patent. There are two major categories of patents. So the first is the utility patent, and that is basically drawn to the function. It covers the words of the claims, cover what you're getting a patent on. They can cover a wide variety of things, methods, manufacturers, things like a nanotube array or a silicon wafer. And the other type is a design patent, and it is the actual design of an article. For example, the design of an iPhone or design of a fixture in your house. The other types of patents are the plant patent for asexually reproduced plants. You can get similar protection for plant variety protection certificates, and some recent changes on that came about in the 2018 Farm Bill. So now you can get plant variety protection on asexually produced plants as well. And also the Farm Bill legalized hemp, and so now you can get PVP protection and utility patent protection on hemp varieties because you can submit seeds. Turning now to the types of patents that are what is involved in a utility patent. I'm going to scroll forward to see if any of these missing slides are still there, and it does not look like they are. So I apologize for that, but I'm going to keep talking about what is missing. So in the typical format of a utility patent, you have the specification, which is the written description of the invention. You have drawings that go along to illustrate your invention, and then you have the claims. And I mentioned the claims before, and that is the most important part. It is the words that are used to describe and claim your product or your process, your composition, methods of making, methods of using. And it is the words are critical. They define what it's covered. And you typically have a number of claims in a patent, and you typically want to go from broad to narrow, and you want to cover different embodiments. So that's what goes into a patent application, and then I'm just going to briefly touch on the types of applications. The first that is usually filed is what is called a provisional application, and it is not examined. It is used to get a priority date. It is, however, important that your provisional applications be well written and drafted in order to take advantage of that priority date. And in fact, if you plan on filing in Europe, to have that priority date, you would also need claims in the provisional application. After a provisional application is filed, you would then ultimately file non-provisionals, and it could be a U.S. non-provisional, or it could be a foreign non-provisionals or through the PCT. And we're going to be finally getting to the slides that are available to you. So under the U.S., you can have continuations, which are patentably indistinct embodiments of the parent invention, continuations in part where you're adding new information, and divisionals where the patent office decided that there's multiple inventions and you have to split it into different applications. So as I indicated before, you have the ability to file and take advantage of foreign jurisdictions. And the primary way in which that occurs is filing a PCT or Patent Cooperation Treaty international application. It does not result in a patent, but it allows you to then delay the filing and get search reports in foreign jurisdictions. And having those search reports, you can evaluate, what's the likelihood of getting your patent in the foreign jurisdictions and be able to take advantage of minimizing costs where appropriate. So now that we've gone through the basics of what the types of patent applications are, what are the requirements in a patent application? So the legal requirements are that it has to have utility or be useful, and that's usually a pretty low threshold. The other major one that is a growing and threshold is what's called patentable subject matter, especially in the United States, where it has to be directed to a process, a machine, manufacturer, composition. It can't be directed to an abstract idea or a mathematical formula, natural phenomena. And ever since 2010, this concept of lack of patentable subject matter has been a real issue and the basis for invalidating many computer-related inventions and some biotech-related inventions. In addition, your invention has to be novel, and what that means is that no single piece of prior art discloses all your claim elements. And in the U.S. and a few other countries, you have a grace period. So if you're able to get your invention on file within 1 year of an inventor's disclosure, you can still file your application. In absolute novelty countries, you don't get a grace period, and that's one of those would be Europe, and there's quite a few others. And so this is particularly relevant in the university setting in that professors, researchers like to publish. And so sometimes you have to take advantage of that grace period because the publication comes out before your application is filed. It also has to be non-obvious, and that is you look at your invention relative to the relevant art, and it's a subjective determination, but putting all that art together, would your invention be non-obvious over that? And one way you can establish non-obviousness is with evidence of unexpected results or superiority, commercial success. The disclosure, this is really into what goes into the application. It has to enable a person of ordinary skill in the art to use the invention make and use it without undue experimentation. The written description requirement is there has to be sufficient description to show that you possessed what you're claiming, and in the U.S. in particular, you have to describe the best mode for carrying out the invention. The typical timeline is you file your provisional application, then you have a year to file your non-provisional, and that non-provisional will publish in about 18 months. And it typically takes 18 months to 2.5 years to get your examination started. And after you've begun examination, it's usually a 12 to 18 month process. And ultimately, you'll either get an allowance or a rejection, final. And if it's a final and you want to continue, you can file what's called a request for continued examination and keep the process going. And it's pretty typical to have at least one RCA. Sometimes there's a need to get your application allowed quicker, and there is a procedure for that called prioritized examination or track 1, and you can get basically a decision within 12 months. But you have to pay a fee, which in the USPTO is $4,000. But I've had success doing that. It's a pretty good process if it's needed. Some best practices for protecting your inventions are, and this is in the university setting, the researchers are going to be the people that are most knowledgeable of the art, And so having them monitor the art closely, and it's also part of the obligation of disclosing relevant information to the Patent Office. So that's definitely a good thing to do, and it can take advantage of other proceedings in the Patent Office, as indicated. Also, keep detailed records of the research and development and the commercial activities and disclosures that are made, because they can be useful for establishing that the invention was independently developed and against people that may take the disclosures and try to work and make derivations of it. And it could potentially support a prior commercial use defense, which I'll mention a little bit later. Also, it's a first-to-file type of world out there for protecting inventions, and so especially in the university context, would be file your provisionals as soon as possible, and even consider filing updates on your provisional as the invention research progresses. Definitely a big issue with universities is avoid any type of pre-filing disclosures if at all possible. If you need to do a disclosure to a company, make sure it's under a confidentiality agreement. And then another big issue with universities is avoid intervening disclosures. And what I mean by that is typically a paper is prepared and maybe published after the provisional, and it may have additional information that wasn't available for the provisional, but before you file your non-provisional, and in that case, it can be a very significant problem, and it creates prior art against your later case. So that is definitely an issue that happens a lot with the universities because of the desire to publish. Moving on to once you have your patents, one of the things that you need to be aware of in your agreements with your licensees is that products that are covered by the patent need to be marked with the patent number and their guidelines for doing that. And if it isn't marked, then that can have a negative effect on your ability to get damages for the sales that are sold before the product is marked. So there is also provisions for virtual marking, and you and your licensees may want to take advantage of that. All you have to do is set up a web page and listing the patents, and it can be changed as more patents are added and things like that. So one of the things that is important, I mentioned earlier, is this prior commercial use defense, and it also has an impact with universities. Is if you have an invention and there's a period of time when someone developed basically a similar product and is selling it, well, they can potentially take advantage of this prior commercial use defense and continue selling at the levels and to the extent they were selling before. However, written in the law was a unique loophole to that, is if the invention was owned by a university when it is made, the person cannot take advantage of the prior commercial use defense. So the universities had good lobbyists when the last Patent Act was written and got that in there. One of the things that also came about with the most recent Patent Act is the ability to challenge patents in the USPTO through inter-parties review and post-grant review. And with respect to the university's aspect of this, one of the things that has come up recently in these types of cases is that some of the universities have attempted to claim sovereign immunity under the 11th Amendment and try to avoid these procedures, and they have not been successful thus far. But it allows people to challenge patents in the Patent Office and get them invalidated potentially. And the advantage of it is that it's typically quicker than litigation, and depending upon it's changed a little bit over time, but there's definitely a sense that in the Patent Office, tends to favor the person challenging the patent a little bit more than in courts. So that's definitely a reason why they're quite popular. As I mentioned, they tend to favor the challenger, partly because the PTO uses a different standard or has used a different standard than would be in the court. So kind of the takeaway with respect to IPRs and PGRs is there's a limited time to initiate them. So universities probably aren't going to be the initiators, but companies may be, and so they're going to be monitoring the art regularly to take advantage of IPR and PGR when they can. With respect to fees, universities can take advantage of a 50% reduction of fees by claiming small entity status, or potentially a 75% reduction by claiming micro entity status. However, I would say you have to take advantage of, you have to use unusual procedures to take advantage of micro entity status, and I think the costs involved with that and the risks make it less desirable than just selecting small entity. Overall, the price difference isn't a huge factor, and the risks are potentially significant. So I don't recommend university clients do that, but it is available. So the other major university-related issue is the Bayh-Dole Act, and so that was passed in 1980, and it allows the inventors to, in this case, their employer, the university, to own patents that come from government-sponsored research. In the past, they were all owned by the federal government, and this federal government back then was spending $75 billion a year in research, and the government had accumulated 28,000 patents, but less than 5% were actually commercially licensed. And in order to try to combat the economic malaise of the 70s, this was passed in 1980 based on the idea that if we get government out of the way, the private sector and the universities will move these things forward quicker and get them in the marketplace. So that was the basis for the Bayh-Dole Act. And, universities have definitely taken advantage of it in the years since. The text is a little small. There's a lot of things in there, but there are requirements under the Bayh-Dole Act. So I'm not going to hit them all, but in general, you have to have a clause in your contracts, your licenses, about the government's rights. You have to report the invention to the agency and inform the agency in a timely manner that you're going to maintain title of the invention, and your applications have to have a government support clause in them, and you have to basically be diligent in filing the application, finding licensees, and getting the invention into the marketplace. And kind of the other main thing there is this government march-in rights. So if it isn't being commercialized effectively, the government can march in and basically take it back. And the government also maintains a license under the technology to use for itself or with other foreign governments if need be. As a note, I may be wrong, but I'm not aware of any time of the government actually using the march-in rights. So it sometimes raises eyebrows, but it really hasn't been an issue. With respect to universities in particular, for nonprofits, there are a few additional requirements. One of which is there's a limited ability to assign the invention. The university would have to share royalties with the inventor, and they have to use the balance of the royalties after the expenses for scientific research or education. And they also, when licensing, they need to give a preference to small businesses. So I know it was quick, but that is kind of the highlights of patents in technology inventions for universities.
All right, and I am Jennifer Visintine, and I will be doing an overview of trademarks and copyrights, and then at the end of that, we will should have some time left for questions. So there are a couple different topics that we'll be talking about both in connection with the trademarks and with the copyrights. I'll be talking about what these types of intellectual property are, how you can acquire rights in the trademarks and copyrights, how you protect the rights that you have, and what you need to do sometimes to enforce those rights or defend claims in connection with somebody else's rights, and then also in connection with copyright a little bit on fair use, because that's an issue that commonly comes up. Although it's not a particularly clear issue, but it is of relevance, particularly in the educational world. So starting out, what is a trademark? Basically, a trademark is your brand, and so it is a word or a symbol or a design, something that you use to identify the products and services that you offer and distinguish them from others. And so it's commonly referred to as a source identifier. It's something that consumers will see when they're looking for your products and services, whether online or in a store or however it is that they're looking for a particular product or service, and they'll know once they see that trademark what the origin of those services are, and helps to distinguish them from others. So in our case, the name Thompson Coburn is our trademark that we use in connection with our legal services. There are lots of different types of trademarks. You'll sometimes hear the term service marks, which is often used to refer to a brand name that is used in connection with services as compared to products. The term trademarks is commonly used interchangeably both to refer to service marks as well as trademarks that are, or brand names that are used for products. And there are word marks, like I mentioned, Thompson Coburn is for our particular name for our legal services, but then you could also have slogans and taglines and the particular stylization. In the university context, I've included up here some trademarks from my alma mater, and you'll see that sometimes the mascot can be used as a trademark. You'll see that on different types of products that are from or merchandise that are from the universities or other institutions. And so those are the examples of designs that might accompany it, different types of logos, such as the MU logo that accompanies the Mizzou mark, or that's in that particular instance it's shown, but also used on its own. And many times other types of things that can be protectable are trade dress or product configuration, which isn't something that comes up quite as much in the higher ed world. But other things are colors or sounds or smells and animations. And those are all things that you see more in other industries. But there are many different trademark issues that can arise in the higher ed world with names and the logos and other branding that accompanies that. So if you are looking for a new trademark, and whether it be for the institution itself or a particular service that the institution is going to be offering, there are a couple of different issues that you will need to consider. And the first two issues at a high level are whether or not you can use the trademark, and then also whether or not you can protect it. And we're going to make available some flyers within the resources section that talk about a couple of the issues that I'm covering today. And so one of those is a flyer that talks about selecting trademarks that works. And so it will go over some of this information and include some additional details. So when you're trying to determine whether or not a trademark is available for you to use, we oftentimes suggest that you start with a trademark search. And the purpose of a trademark search is to determine whether anybody else is using or has registered or applied to register a trademark that is similar to the trademark that you are interested in doing. And there's different types of searches that you can do. Oftentimes people might search just using Google or your search engine of preference to search the internet and see if anybody else is using a similar name. There's also search functionality available on the United States Trademark Office's website. It's not the best functionality, and it might take a little getting used to, but it does provide an option for looking to see if anybody has filed a federal trademark application to register the mark that you're interested in. And then attorneys also often have different types of searches. And so, for example, we offer what we would refer to as a preliminary search that would include the federal records as well as state records. And then also another option is to do a comprehensive search, and that would cover both federal and state records as well as unregistered uses. And when you do these types of searches, you're looking for other marks and trying to evaluate the risks that might be associated with your use of the mark and determine whether or not those risks are acceptable to your institution or whether it's high enough risk that you want to move on and consider another mark. But the types of things that you might consider when doing those searches are the similarities of your marks and the other marks that you identify in the search, how similar the goods and services are. So if you have a particular mark of interest and you find somebody else has registered it, that might not be a problem if that other party's goods and services are different. So if you're looking at doing it for educational services and somebody else has used or registered that mark for car parts, that may be irrelevant to your use. They're in different channels of trade. There's different consumers that are of interest. There's for different purposes. Those types of factors can all come into play when you're determining whether the risk is high enough that you need to move on to a different mark. And the standard that you're looking at there is likelihood of confusion. Are consumers likely to be confused that your product or service is somehow associated with a product or service that is offered by the other party who has a similar mark? And so that's why factors such as the consumers of interest and who's actually going to be seeing the mark and the exact nature of the relevant goods and services comes into play. Another thing that you'll want to consider is whether or not you can really protect the trademark. And in doing this, you're looking at how distinctive your trademark is. And so the more distinctive your trademark, the better the opportunity that you will have to protect your trademark. And when I talk about protection, that comes into play both as far as registration as well as enforcement against third parties. Depending on the circumstances, the mark may be too simple or generic to actually protect. And so this is an example. This just shows the spectrum of distinctiveness that's often used when determining the strength of a trademark. And starting down at the bottom, you have generic names, and that is a name that is not protectable in connection with a particular product or service. So in this case, we have beauty shop. That would be the generic name for a beauty shop and is not something that would ever be protectable. And then you move on to the descriptive trademarks, and those are trademarks that may describe some aspect of the service that's being provided or the entity that is providing it. And the example there is American Airlines. So American Airlines started out as a trademark that was not initially protectable. It was just something that would be viewed as a descriptor of the services because it was an airline that was located in America or providing services in America. And as a result, those are terms that other people might need the ability to use, and they could not claim exclusive rights in that trademark. Now, over a period of time, descriptive trademarks can acquire distinctiveness. And that basically means that through use of the mark for a long period of time, through lots of advertising and branding and promoting the mark, consumers eventually come to recognize it as a brand. And once it becomes recognized as a brand, then you can claim trademark rights in that. It allows you to get a type of registration on the principal register, which would not have otherwise been available. If a mark is viewed as descriptive, registration is available sometimes on the supplemental register, but that's not going to provide all the benefits associated with a registration on the principal register, which is where you really want to be when you get the trademark registration, because it provides greater benefits and allows for enforcement and such. And then the other types of marks are suggestive, arbitrary, and coined trademarks. Those are ones that are going to be protectable from the get-go, from the time that you adopt those marks. And they are marks where you either need to obtain additional information or use some sort of additional thought process to really understand the connection between the mark and the products or services that you offer, or they actually may have no association whatsoever. And so Apple is up there as an example of an arbitrary mark, because as applied to computers and phones, it really does not have any meaning. If you were to use that for fruit, it would fall back down into that generic category and not be protectable. If it were to be used in connection with something like candy to describe the flavor of the candy, it wouldn't really be protectable unless you had made enough use of it and were really the only one using it in some particular way that you could claim exclusive rights. So the descriptiveness would really prevent you from obtaining rights there or enforcing rights. So it's up at that upper end of the pyramid that you really want to be in order to have a protectable trademark that you can enforce against third parties. And the other thing, just going back to the strength of the mark for a moment, the other thing that can come into play, aside from these issues that I've mentioned here, is how many other people are using the mark. If there are a lot of different people using the same mark, and maybe they combine it with different terms or have other differences, then the term may be weak within the industry, and so you might also be able to coexist if your mark has other differences, but it does make it more difficult for you to then try to enforce the right against others. So how do you establish trademark rights? And it's really actually quite simple in some respects, because if you just start using your trademark in connection with your services, you can start establishing trademark rights. Now, that's assuming that there's not somebody in that area that already has trademark rights that you would actually be infringing. But if, for example, you open up a higher ed institution in a particular geographic area, you may have or may be able to acquire what we refer to as common law trademark rights. And so those are basically unregistered trademark rights that are limited to the particular geographic area where you are providing services. And your rights outside of that area don't exist at that point. So it's really just in that one particular geographic area where you're using a trademark. And if you want to get rights elsewhere, then you need to obtain a state or a federal trademark registration. State registrations can give you benefits in the state in which you have registered the mark, but they're not going to provide the same level of protection as a federal trademark registration, which really enhances your rights to a much greater degree. And so state registrations, I think, are generally less common unless the applicant or trademark owner is not able to obtain a federal trademark registration because of either conflicts or it's not really using this mark in U.S. commerce or one of the other requirements for the registration. So if you're going to rely on common law rights, the most important thing for you to do is make sure that you are using your mark. And really the use comes into play regardless of whether you use the mark to obtain your rights or you also obtain a registration, because you will ultimately need to prove that you're using the mark in order to obtain a registration. And another one of the flyers that we have provides some guidelines on using the trademark. So, and this applies particularly for something where it starts out as descriptive. You want to make sure you're using it in a distinctive manner, in a way that's really perceived as a trademark use. You don't want to ever use your trademarks in a way that might be perceived as generic or descriptive, because then you could eventually lose your trademark rights in that name. So as I mentioned, there are many different benefits of a federal trademark registration. The federal trademark registrations provide nationwide protection, and from the time you file your application, that essentially put your stake in the sand as far as the trademark and what rights you have. And anybody who starts using a mark after that is confusingly similar, you would be able to stop them from using the mark as you move into that area. And so you would have prior rights over them, and the registration is what gives you those rights as compared to just your use in a limited geographic area. So if you open up a facility in St. Louis and file an application and then later decide to expand to another geographic area, and after you filed your application, somebody else started using a similar name, you might then be able to stop them from using the trademark as you expand into the other areas where they have started operating. And there are other benefits, as noted up here on the slide. There's the ability to use the registration symbol, which applies for both registrations on the principal register and the supplemental register that I mentioned earlier. Some of these are more specific to the principal register, such as the presumption of ownership and validity. But regardless of the type of registration, it is helpful because it can notify others of your trademark, and they'll be aware of it if they conduct a trademark search, and it might act as a deterrent for others who are looking to pick a new name. So after you've selected a name, or I guess in the process of selecting a name, you want to think about trademark enforcement issues. one of which is whether or not you have protectable rights. And that goes back to the issues that we talked about earlier with respect to the strength of the mark and whether it's something that's coined or arbitrary or suggestive versus something that's merely descriptive or generic, and wouldn't really provide a basis on which to challenge somebody else's mark. And then the second issue is whether or not the marks are confusingly similar. And this goes back to the other issues that I had talked about in the context of the trademark searches, where you're looking at the similarities between the marks and the goods and services that are offered, the marketplace, how strong the mark is, and other factors along those lines. If there is an issue with a third party, at the trademark office, so if you're concerned about somebody else's registration of a mark, you can file proceedings at the Trademark Trial and Appeal Board, and disputes that are heard there are really specific to the ability to register the mark at a federal level. So that could happen, that happens in the registration process where the trademark office essentially publishes an application and third parties then have an opportunity to oppose it. Now, if somebody's concerned about your use of a mark or you're concerned about somebody else's use of a mark and you want to stop the use and not just the registration, then that would need to be done through a state or federal court. And different types of remedies are available, including injunctive relief that might require you to stop using a mark or to destroy merchandise or advertising materials and other things that actually show the trademark in connection with the relevant goods and services. And so it's because of those types of remedies that it's so important to conduct the search at the beginning and try to steer clear of a mark that might ultimately result in issues down the line and just wasted money when you have to destroy the materials that you created. And so now I'm going to move on to copyrights. And copyrights protect works of authorship. And so it protects things that have original expression, so photographs and books and movies, music, things along those lines are all subject to copyright protection. The copyright protection for those types of work really extends only to the expressions of information that you have. It doesn't protect the underlying fact or just concepts or ideas that you have generally. It's just the way that they are expressed. And registration is not generally required unless you want to enforce your copyright against somebody else, in which case you would need to have a copyright registration in order to sue the other individual. When you have copyright in a work, you have certain exclusive rights. And so this is a list of the rights that you have as a copyright owner in the works. And so you have the right to reproduce the work, to prepare derivative works. And derivative works could take many different forms. If, for example, somebody writes a book and then somebody else turns that into a play and then somebody else turns that into a movie, those would all be viewed as derivative works of the original. And it's the owner of the copyright in that original work that really has the right to prepare those derivative works. The owner is also the person with the exclusive right to distribute the works, to perform the works, in this case, for example, of music or plays, and to publicly display the works. So how do you obtain a copyright registration? Again, it's pretty simple. If you just put your idea or your expression into a changeable medium, so if, for example, you write a poem or take a photograph or write a book, that is protected by copyright from the time you put it into that medium. Now, we do typically suggest that people put a copyright notice on their works, and so that's, again, a simple thing of putting the word copyright or the copyright symbol, the year that you published the work, and then the owner of the copyright. And then sometimes people like to write all rights reserved, just to clarify that they are reserving all rights in the work and not really providing it to others for unauthorized uses. And then also, there is a copyright registration process that can be accomplished online. And the fees that are for the Copyright Office are relatively low. And the forms are actually relatively simple, assuming you are able to collect the information you need, which is along the lines of the owner of the copyright, how that owner obtained rights if it was somebody other than the author of the work, the title of the work, and information about the publication of the work and where the author is located or resides. And so those are relatively simple to obtain and relatively low cost. And There are many benefits for the registration. As I mentioned before, they are required to sue individuals or to sue infringers, and they can also result in greater damages in the event that you do need to sue somebody for infringement. In order for infringement to occur, it requires both the copying of a copyrighted expression, and so that requires both access and substantial similarity. So if you have access to somebody else's work and then you create something that is substantially similar based on that, that would be infringement. If, on the other hand, you create something that's substantially similar to somebody else's work, but you didn't have access to their original work and you just independently created it yourself, that would not be infringement. And infringement can occur in different mediums than what the original occurred in. So if, for example, somebody takes a photograph and then somebody else creates a sculpture based on that photograph, that could be infringement even though one's a photograph and one is a sculpture. Now, there are many exceptions to the exclusive rights, or I guess a couple of exceptions to the exclusive rights in copyrights, one of which applies specifically to nonprofit educational institutions. Under the statute, there are exceptions for nonprofits who can then display or perform work in their teaching activities, whether it's in the classroom or through distance learning. It allows them to use materials for those teaching purposes. Now, for those in the for-profit sector, there is also the fair use defense. And under the fair use theory, there is a certain amount of copying of copyrighted material that is permitted or may be permitted if it meets certain criteria. And I'll get into the factors on the next slide. But the rationale here is that the public will benefit from the use of copyrighted material. And so there is some degree of use that may be permitted for purposes such as commenting on somebody else's work or criticizing somebody else's work or for educational purposes. These are the four factors that are listed within the copyright statute that should be taken into account when determining whether or not the use of somebody else's work is fair use and thus not infringing. These four factors are not supposed to be exclusive, but these are what courts most commonly look to when determining whether or not the use of somebody else's work is infringement or if it qualifies as fair use. And the first factor is the purpose and character of the use. So is it a commercial use or is it a nonprofit educational use? And if it's more on the commercial side, then that tends to favor infringement versus something that's being used for nonprofit or educational purposes that would be more likely to be viewed as fair use. Also relevant here is how transformative the work is. If it's just copying the underlying work, then that's one thing. But if it's more transformative, if you've taken a work and commented on it or criticized it or made some changes to it, then that's more likely to qualify as fair use. Other factors that come into play are the amount of the work that was used. So if you have a 500-page book and you copy 3 sentences, that's more likely to be fair use than taking 450 pages of that book. And also is the nature of the copyrighted work. Is it something that is more factual in nature, which has less copyright protection, or is it more creative? And then also the economic impact of the use on the original work. So if you have taken 3 sentences from that book, it's unlikely to affect somebody from the purchases of that book, whereas if you take 450 pages, it's probably going to harm the value of or the potential market for that other work because now people don't need to make or obtain the book themselves. Aside from the fair use analysis, obtaining permissions and licenses is probably the safest way to be able to use somebody else's work. It's a little bit more clear-cut than the fair use factors because there's a lot of gray area in there. And so getting the licenses or permissions are the safest course of action. And just a couple of fun examples of what has qualified as fair use and what has not. This is a song, the Roy Orbison song of Pretty Woman. The lyrics are up there. And many years later, Two Live Crew made a song that kind of copied off of that as far as the tune and the lyrics, tracked it a little bit in the sound, but this was ultimately determined to be fair use because it was viewed as a parody because they were commenting on the underlying work and the idealistic views of Roy Orbison and his song as compared to the realities of the world in which Two Live Crew lived. And so that was found to be a parody and fair use. In contrast, the Cat Not in the Hat, there was a parody or they called it a parody, but it was ultimately found not to be a parody. It was a book that was based on The Cat in the Hat, but it was really just a story about O.J. Simpson and the murders that he was accused of. And here they found that this was really just to draw attention to the work, and it wasn't really a commenting on the underlying work, and so there was no fair use there. Now, there are many different types of resources that are available out there. I just included a couple of examples here. The Copyright Office has a publication that talks specifically about reproduction of copyrighted works by educators, and it gives some guidelines on what would qualify as fair use and what should be permissible. And then another link to a website where they have a variety of guidelines related to fair use. Now, as far as infringement, I alluded to this earlier, there are differences between the infringement remedies that are available if you have a copyright registration versus those situations where you do not. If you don't have a copyright registration, you need to prove your damages, and so if you lost profits or what royalties you would have obtained had somebody properly licensed your work. If, on the other hand, you have a timely registration, so you get it before you publish the work or within a certain period of time after that, then there can be a presumption of damages, and that way it allows you to enforce your copyright even if you think you might have a difficult time actually proving that there was some large amount of money that was lost because of the infringement that occurred. And attorney's fees are also available. And so now I think if there's any questions, we have a few minutes for that.
Yeah, good. And I'll jump back in too, and just I always like to remind folks a couple of things. First of all, I want to say thanks to Zarin, and I want to say thank you to Jennifer and Steve. And as Steve noted, we dropped a few slides there out of the deck at the very beginning of the patent section. We will get those put back in, and we will make sure we get the full deck circulated to everyone who's on the registration list, so you'll have those slides. And Steve, appreciate you still going over that content. So that way, when you get the updated slides, you can come back and listen if you want to do another round of the webinar on demand, and you'll have the content along with the audio. Just a reminder, in addition to the webinar series, we do have our blog, REGucation, where we talk about different types of matters that impact the higher education community. And again, if you're not able to join us for a live performance of one of our higher ed webinars or any other webinar firm may offer, and we do a lot of things in a lot of different areas, we do have a lot of content on demand, free, that you can cover at your convenience. There are photos of Steve and Jennifer, and Steve, no beard though. We got to get you an updated photo. I bragged on your beard, and it is not in the photo. And there's me. I like to call this photo man auditioning for local production of Dead Poets Society. I probably need to get an updated photo of myself. So let's go to questions and answers here. Or at least we'll see if we have questions, and we'll do our best to get the answers. Looks like we don't have any. So what that always tells me is that we covered all of the content so thoroughly and so completely that no one had anything to ask. Thank you all again for tuning in. We really appreciate it. Keep in mind, we do have another webinar coming up next month where we'll be covering First Amendment issues, so it should be very interesting. There's a lot, of course, always going on in that space in the higher education community. Hope you have a great weekend, and again, thanks for tuning in to the Thompson Coburn Higher Ed Webinar Series.